I'm Karen Brady. Um, we had a request for this a couple of months ago, this particular topic. So this year is our year of education. In odd numbered years, we work on educating our clients and the public. And then in even numbered years, we work on updating the clients on our maintenance plan. They all get new updates in their plan. So that's a busy year for us. So we don't do that in 20 and even numbered years. But today we're just going to talk about a perennial question I get is which is better, a will or a trust? The lawyer's answer to that question, which is the lawyer's answer to most questions, is it depends. Okay. So let's talk about what they are. But first, you need to understand that although I'm happy to answer questions like that, in the end, it's not really about what documents are. Okay. Documents are just the documentation of your wishes. They're a means. I like to think of them as a vehicle. Okay. But we need to know about where you're going. And we also need to know about what you have as fuel for the vehicle. And you'll hear me talk about that in terms of assets in a little bit. But that's always the first question. So someone says, which is better, will versus trust? And I give them what may sound like a flippant answer. It depends. It's because it depends. What do you have and what do you want to do with it? That'll help us decide what the vehicle is to get there. Okay. So sometimes I tell people that wills are like bicycles and trusts are like cars. Okay. A bicycle will get you where you want to go. It might be harder to get there, but it's less expensive. And in some cases, it might be the best way to go because, for example, the path is all bike path and there's no roads. Okay. Where a car or a trust is going to be more expensive, but it will get you where you want to go if you fueled it properly. And in some instances, it's easier than a bicycle. So I know everybody wants to make sure they're not spending more than they have to. And I think I have a reputation in the community for helping them do that. There's plenty of times I tell people who came into me and said they want a trust. I'm like, well, I'll sell you a trust, but you know what? You don't need one, you know. So let's talk about a will. So a will is always a set of instructions about what to do with your assets when you're dead. Okay. Those last two clauses are very important. It only relates to your assets and it only comes into effect when you're dead. The one exception about assets is it's the only place you can nominate a guardian for your minor children upon your death. When you name a beneficiary in a will, here's one of your vocabulary words that you're going to learn today. That person's called a devisee. Because when you make a gift in a will, it's a devise. I don't know, I just get a little uptight if I start using the term beneficiary because I know that means something else. That means the party that you name for your life insurance and the party you name for your IRA and the payable and death beneficiary of your bank account. That's a beneficiary. So that's why we see the term beneficiary, but you'll sometimes see me use the term devisee because that's what lawyers will use.
Is a devisee an executor?
No, a devisee is the person set to inherit in your will. So if I leave $10,000 to the animal shelter, they are a specific devisee. They're getting a specific amount. If I leave all of the assets under my will to my husband, he's a residuary devisee. He's getting whatever's left after the specific devises are made. So a colleague of mine came up with this. He wants you to know that a will is a ticket to probate court, because one of the myths we're going to bust today is that a will avoids probate. It does not avoid probate. As a matter of fact, the only way will gets carried out for the most part is in probate court. a will gets admitted to probate. The judge appoints the personal representative. Natasha, what you asked about the executor, okay, in Colorado, we use the term personal representative. All of that is done by the probate court. The personal representative gets their authority from the probate court. So I get people who say, well, I'm named in the will, why won't the bank let me get to the bank account? And I'm like, because the bank is waiting for the court to approve that and give you the authority through the court. Okay. So wills are the opposite of avoiding probate. If you want to rely on a will, it's going to go to probate. Now, you need to understand my philosophy is avoiding probate is not always a bad thing. And sometimes it's just fine. We should not let the need to avoid probate be the tail that wags the dog, right? That's why I want to focus on your goals and where you want to go and what you have to do with it. And then we can think about what vehicle we want and not just go, well, I know I want to avoid probate.
So all the myths that we hear about probate or what we know, like probate takes a long time and costs a lot of money.
Right.
Is that still true?
No.
Okay.
So probate is a set of tasks we have to follow that are mandated by the court. And there is a certain amount of waiting time that has to be involved. At a minimum, you can't close a probate until 9 months from the date of death or 6 months from the time the case was opened. But, or 6 months from the date the case was opened.
Well, you don't open the case until they die, right?
Correct. You won't open the case until you've admitted the will to probate or filed because they don't have a will. Okay. So the timing issue, I think, is a red herring. Most of my clients are advised we will not close the case, or they could tell me different, but I'm strongly advising them not to close the case until a year from the date of death. But that doesn't mean we didn't distribute most of the assets in the meantime. That year from the date of death is a safe harbor date after which no creditors can come out of the woodwork. Okay. So I had one client who didn't listen to me. He distributed all the assets before the year was up. And the worst possible creditor came out of the woodwork, meaning the IRS.
Ooh.
Okay. So I told him he had to do one of two things. He had to pay the IRS out of his own pocket, or he had to get his sisters to give him some of the money back that he'd already distributed so he could pay the IRS from the estate. Okay. So that's why my personal representatives are told that story, so they know why I'm saying, let's keep some money in the account, the estate account, until a year from the date of death. Okay. Guess what? I tell them the same thing if it's a trust, because that 365-day safe harbor applies to all creditors. Okay. It doesn't matter if our vehicle was a will or it was a trust. We still have to worry about creditors coming out of the woodwork for 365 days.
So even IRS, if it was an IRS issue, even after 1 year, IRS couldn't come after you.
I don't know that I could promise that, but I'd have some arguments to them to go, probate's closed.
Yeah.
You can't make me reopen it. Trust is closed. You can't make me reopen
And
it.
it's been a year.
As
so-
long as my personal representative or my trustee didn't have knowledge,
Okay,
right? And couldn't have knowledge attributed to them, like you should have known is an argument under
Okay.
some of this.
uh,
Okay. What the other thing, so that's the timing issue, Natasha.
Yeah.
The other thing about probate is the expense. Okay. Literally, the expense of probate is like $300 that we pay the court. The rest of the expense is personal representative fees and lawyer fees. it is true that if we've got a streamlined situation, there's going to be fewer attorney's fees and fewer personal representative fees. And the planning required to have a properly funded trust increases the likelihood we'll have a streamlined situation. Okay. So a lot of the literature out there will tell us that trust-based plans are less expensive in attorney's fees than will-based plans on average. And I can't really argue with that. But that average is based as much on how much planning was done beforehand. Because somebody who did a will 40 years ago and stuck it in a drawer, almost it's like they didn't have a will. There's not necessarily a lot of planning in the naming of beneficiaries, or their accounts are all over the place. That's not as streamlined as someone who's had to plan to fund their trust. Okay. So that's why I think there's often a difference there. Okay. I had a client in my office yesterday who was insistent that she needed a trust for her planning because she'd done the probate for her father, and it had been a very miserable experience for her. I inquired onto what was going on with the misery, and it was like, well, my siblings argued about this, and my siblings gave me pressure about that, and I didn't know what I was doing here. And I'm like, okay, you know what? It wasn't probate that caused those problems. It was your siblings. It was your siblings insistent that you couldn't consult a lawyer to help you figure all this out. Probate was just filling out those court forms. If you'd had a trust, I predict you would have had just as many problems because your siblings still would have been jerks. Okay. So that's why I kind of approach every situation in estate planning with, why won't a trust be the best solution? So I already have one foot in the camp of a trust is a good idea, but there's plenty of times that foot goes back to go, no, this is not one of those cases. Okay. So one thing about a will that the literature makes a big deal out of is it's a public record. And that's true. I'm not sure if you've ever gone down to the courthouse and said, gee, I just want to see all the wills that were filed today. But if you're like, my neighbor died yesterday, or it has to be 5 days. My neighbor died 10 days ago. I'd like to know what his will said. If and when it's lodged with the court, you can see it. But you literally have to go and ask for so-and-so's will. And I don't know if I've had anybody ever do that. Okay. So we'll talk about the wills versus trust analysis, but the public record thing isn't usually a big deal. So what is a trust? So trusts come in all kinds of flavors. And so the first thing I want to point out is today we're talking about what's called a revocable living trust. This is a trust that's established while you're alive. So sometimes you'll see the Latin term inter vivos, inter vivos. We argue amongst us about how that's supposed to be pronounced. And it's revocable. When it's set up, you can always undo it as the trust maker if you want to. Okay. Every trust is really a legal arrangement that involves three parties. So think of the triangle. Okay. One party is the person who created it. That's sometimes called the grantor, the settlor, the trustor. In a lot of my documents, we call it the trust maker, because frankly, the ors and es confuse me. The other party is the trustee. That's the person appointed in the trust to manage the assets in the trust. And the job we all want is the beneficiary, the person we're managing the assets in the trust for.
Can the trustee and the beneficiary be the same person?
Yes, when we have revocable living trust, often all three of those roles are filled by the same person while they're alive and well. Okay. So I can set up a revocable living trust. make myself the trustee. And while I'm alive, I will be the beneficiary. The rules in the trust will also describe what happens when I can't be trustee. Who's my successor as trustee? Because I'm either incapacitated or deceased. And who's my successor as beneficiary when I die? Now, I can set up a revocable living trust and name myself and my husband and my kids as all beneficiaries all at once. And that doesn't have to wait until I die. The assets in a revocable trust avoid probate because this is where we need to understand what probate is. Probate is the court-approved transfer of assets of a dead person. The reason that a trust avoids probate is if all of the dead person's assets are actually in the trust, the dead person doesn't own anything. So you have to change the asset ownership to the trust. Or the asset has to have beneficiaries, like a life insurance policy does. When it has beneficiaries, it's not a probate asset. Or the asset has to be held in Colorado, the only way to do this is joint tenancy. So cars and some cars and real estate and some bank accounts can be in joint tenancy, meaning when one owner dies, the surviving owner or owners automatically inherit it. No probate needed. But if it doesn't have a beneficiary, it doesn't have joint tenancy, then if it's in my name, it's going to be probated when I die. So go ahead.
Except when it's in your name, it's going to be probated when you die unless you have a trust.
If it's in my name and I have a trust, it won't matter. It'll still be probated because the trust doesn't have it in its name. So a trust has to be thought of like a bucket. I can build the bucket, but if all my assets aren't in the bucket when I die, they're going to get probated.
Okay.
To make it a non-probate asset, I need to have the trust own it and have all the assets in the bucket. Even if I have one piece of real estate outside the bucket that's in my name, it will be probated. A probate will be necessary.
Just the one and nothing else.
Just the one. Some people find this a little crude, but I say that probate is like being pregnant. You're not a little bit pregnant. Okay. You're either in probate or you're not. Okay? And it doesn't matter. Once we start a probate, that's it. The process has to go through the process. It doesn't matter if I had one asset or if I had 25 assets.
So I have heard that in a revocable living trust, you don't put things that are transient, such as your vehicles, because you buy and sell cars all the time. And
I disagree with that to some degree. Okay, so one thing we won't put in a revocable trust is your retirement plan, but that's tax driven. Because to put it in the trust, we have to take it out of the retirement plan, right? And the retirement plan isn't supposed to be a probate asset anyway. You should have beneficiaries. Okay. When we first set up a trust for clients, I tell them I'm not too pushed about putting 1 or 2 cars in it. And I have clients who have 15 cars, and I don't want them taking the same advice. Okay. The reason I'm not too pushed is because the car it's a probate asset if it's in your name, but it's depreciating in value. And we have a little bit of wiggle room. If outside the trust, there is a probate asset or maybe several probate assets, but none of them are real estate, and the total of them is less than $86,000, we can use what's called a small estate affidavit. So consider that a microscopic probate, a no court probate. But all it really is an affidavit where you go to the bank where that one bank account is that doesn't have a beneficiary and say, I need to collect that. I've been named in the will to be the one to manage all this. So I need to collect it and pay the bills and give it to the beneficiaries. If the total of assets outside the trust are less than 86,000 and none of them is real estate, we can use that microscopic process. Okay. So I rely on that for cars. Mostly because I just don't want my clients to have to mess with the DMV. Okay. To take their existing car and put it into the trust. But I also tell my clients, I want the next car to be in the trust. When you buy it in the name of the trust. That's no more hassle than buying it in your name. And now we've got it in the trust. Natasha, some of that, what you heard about cars, is what I think is a misplaced belief that if the car is in the trust, now all the assets in the trust are subject to creditors. Let me make something clear. All the assets in the trust are subject to creditors no matter what. Okay, because it's revocable. If you were to try to tell a judge, I don't have to pay that creditor, or that creditor can't attach my assets because all my assets are in the trust. The judge would go, yes, but it's a revocable trust, and hereby I order you to revoke it so that your creditor can get your assets. So there's no creditor protection in a trust anyway. But that's why a trust avoids probate if it's properly funded. That's a big if, because there's no probate assets when all is said and done. We put them all in the trust. A trust also can manage the assets that it has during incapacity. So it also conserves, I don't want to say a power of attorney substitute, but let's say a co-pilot with a power of attorney. So the assets in the trust, remember I said that the trust will name a successor trustee if I'm incapacitated. So if I'm incapacitated and my house is in the trust, it's my successor trustee that manages my house. If my bank accounts are in the trust, my successor trustee manages my bank accounts. So a trust works to both manage assets during incapacity and at death. I've told you that probate is the court-approved transfer of assets of a dead person. Probate is about filing the right documents with the court, notifying the heirs and the creditors, inventorying the assets so that the heirs and creditors know what they are, paying all the debts, and then distributing what's left to the devisees, if there's a will, or the heirs if there's no will.
So with the trust, you don't need a will?
Nope, that's not true either. But with the trust, you hope you won't need a will. So with the trust, we do a will anyway. And the reason we do the will is because there's always a danger that there's something that didn't get into the trust. Okay. I had one client, I had done her planning for 10 years before she died. I was supposed to know every asset she had. But somehow she didn't know, or she forgot that she'd inherited 2% of an oil well through her father. Okay. 3 years after her death, they wanted to drill on that oil well. And so they contacted her family and said, we need you to probate that asset so that we can write you the checks. So there's always a danger that something's left outside of the trust. And that's what a will help us do. Now, I think I talk about this later, but I'll cover it now. That kind of will that we do with a trust is called a pour over will. Think of it as a pooper scooper. Okay. If there's a probate asset that didn't make it to the trust, the will says you've got to go through the whole probate. But when that asset's left, the devisee is the trust. So then it ends up in the trust and it gets distributed according to the trust. Okay. So think again about what those things were. Collecting the assets, paying the bills, distributing what's left. Back to your question, Natasha, guess what? I got to do that anyway, even in a trust. I got to collect the assets, I got to pay the bill, I got to distribute what's left. Probate is just about filling out those court forms, okay, getting your authority through the court. So yes, there's more I's to dot and T's to cross in a probate because the court's looking at it going, did you do X? Prove to me you did X. Okay, prove to me you gave notice to the heirs. Prove to me that you've distributed the assets. So there is that extra work. But most of the bulk of the work is done either way. This is my trust. It's mine and my husband's, okay? Guess what? When I die, it doesn't grow arms and legs. It's still not gonna go to the bank. It's still not gonna sell my house. It's not gonna clean out my garage. I wish it would. Okay, that still falls to people. Whether my assets are in the trust or we did things through a will. So let's talk about comparing those two. Which one avoids probate? If it's properly funded, the trust does. Which one controls your assets after death? Either one of them. Which one of them also covers incapacity? The trust does. That can be important because I get a lot of people who are like, I'm named as personal representative of the will. Dad is in the hospital. I need to manage dad's assets. And I'm like, apples and oranges. The will doesn't matter until your dad's deceased. Okay. And somewhere in the last, say, 2 decades, there's been a shift because a long time ago, people would, even 20 years ago is a long time, but that long ago, people would go to a lawyer and the lawyer would say, sure, I can do a will. And they do a will and that would be it. The lawyer wouldn't say, yeah, but you need powers of attorney too. It just wasn't in the radar the way it should be. And I think it is more now for all attorneys. And I am evangelical about powers of attorney. Everybody needs a power of attorney. Not everybody needs a will or a trust, but everybody needs a power of attorney. Okay. Which one is not public record? So quote, privacy, unquote, the trust. Okay. Which one costs more? A trust is almost always higher. It's more work for the lawyer. It's more hassle for you, but that's not really a dollars and cents cost. Okay. Wills are almost always less expensive to pay for when you're going to a lawyer. What's the long-term cost? I don't know. It depends on what your goals are, what your assets are. So we're going to talk about that. Okay. Common myths. Trusts are only for the wealthy. I do not really look at numbers when I'm trying to decide if a trust is right for a client. There's people ask like, what's your threshold? If I have more than X number of dollars, should I have a trust? I'm like, no, that's not how I look at it. It's more what you're trying to accomplish and what are maybe the impediments as well as the buckets. We talked about the myth of wills avoiding probate, and it's the opposite. They go through probate. Trusts are complicated and expensive. What's complicated about trusts is the need to do the work beforehand, to put the assets in them, not before the trust, but before you die, right? Where you can do a will, stick it in a drawer and not have to think about it again. And then the work falls to the person you left as personal representative. Where if you're going to make a trust, you need to make sure that you're prepared to fund it. And that may not be complicated, but it's no fun. A colleague of mine says there's no fun in funding. Trust, I've done wills that are almost as expensive as some trusts because it really depends on the complexity, right? That's how I determine the cost of doing any plan, is how complex is it? If you've got minor children versus everyone is an adult who's inheriting outright, it's more expensive. If we've got to deal with out-of-state property, it's more expensive. If we have to deal with a special needs child or beneficiary, it's more expensive. And it doesn't matter if I did a will or trust. So once I look at a will and I add in all those extras, it can be as expensive as a simple trust. But the simple trust wouldn't fit that client, right? They still need all those extras because that's their situation. So there are plenty of people who benefit from having a trust. It's just not everybody, okay? So when I inquire with a client, a prospect who's come to ask me about the will versus trust analysis, I start to ask about their assets, but I'm not asking about how much. I'm asking about where. What are the buckets where your assets are? So the answer might be, I have a house. The answer might be, I have retirement plans. The answer might be, I have life insurance. I have investments. I have a second home in Arizona. Okay. All those buckets tell me something about whether will is going to be the best solution or a trust is going to be the best solution. What I'm looking for is first, is it going to go through probate? If someone tells me almost all of their assets except $20,000 in their savings account is in their retirement plan, I'm not doing a trust because it's all going to have a beneficiary except that savings account. Right? Why would I create this beautiful trust and I can't fuel it? So that person doesn't have the right fuel for the truck, for the car. Okay. Someone else may come to me and say, I have a house, but I want it to go to one single person. And I may go, well, you know, we might just end up doing what's called a beneficiary deed. That's a deed that names that person to inherit when you die, like you name the beneficiary of life insurance. It's something you can revoke and undo anytime you're alive, but as long as it's on record when you're dead, that's what's going to happen, and where there won't be a probate. Now, caveat here, I only recommend beneficiary deeds when we have one beneficiary. If my mother had come to me and said, I think I need a beneficiary deed, I'd have said, Mom, that's a bad idea because you have 3 beneficiaries.
Yeah.
Right? And what you would be doing to me and my brothers is making us joint partners in a real estate venture. And I don't want to be in that position with my brothers. I don't want us to be all like in a 3-legged race, all having to decide what we're going to do, because my brothers and I would all have to unanimously agree on even the smallest decisions. Do we sell the house now? Do we wait until we can fix it up some? Do we sell the house now and then, or do we wait a while till the market gets better? Which realtor are we going to use? Which carpet are we going to replace? All those decisions fall to the person who's getting the house or has to deal with the house if we're going to sell it. Do we sell it or rent it? Right? I didn't want to be in that position with my brothers, although I think we would work it out. I know plenty of my clients for whom they would not work it out. Okay. And you're not doing your family any favors when you put them in that role. There is where probate is a great idea, because probate puts one person in charge, the personal representative. That person is in what's called a fiduciary role. That's a position of trust, meaning they have to do the job with the interest of everyone taken into account. They can't sell themselves the house for $1. For example, okay. They can't decide to live in the house and not let anybody else get a benefit from it. But only one person has to deal with the assets in the probate estate. And that's, I think, far preferable than trying to put people in a real estate venture and say, up, figure it out. Okay. So there are times when I look at clients and go, you could avoid probate. You could do a beneficiary deed and name beneficiaries for all your bank accounts, and guess what? There won't be a probate. But that's not going to be meeting your goals to make sure your family's still talking to each other at Thanksgiving. Okay? That's where avoiding probate would be the tail that wags the dog. If the goal is to get the assets to the family in a way that creates the least hassle and disharmony, that won't meet that goal. If the goal is avoiding probate, it will, but I don't ever see anybody. The true answer to avoid probate is to name the, and taxes, is to name a charity as the beneficiary of all your assets. You won't pay any taxes or estate taxes or anything, and guess what? You will go through probate because you have a beneficiary. And when I tell that to people, like, well, yeah, I wanted to go to my family. I'm like, exactly, you have other goals besides avoiding probate. Let's meet those goals and then see if we can avoid probate too. When do I know a trust is the better choice? The red flag is always if they own real estate in more than one state. Because we have to probate where the real estate is. So if you have property in California and property in Colorado, as a Colorado resident, if you die and both of those assets are in your name, we have to probate in Colorado, and then we have to hire a California lawyer to do what's called an ancillary probate. Think of it as a mini probate in California, because the Colorado court has no jurisdiction over California. So even lawyers who don't do a lot of trusts are like, yeah, that's definitely where we're going to do a trust. Okay. I also remember the buckets. If a client has a lot of different buckets in a lot of places, and some of them are going to pass by beneficiary designation the way they are, some of them are going to pass by joint tenancy, and some of them are going to pass by probate, I might recommend a trust just so that we get everything under one umbrella. Because clients don't keep track. Did I buy? Oh yeah, that's in joint tenancy. And I thought it was going to go according to my will, but it's not. It's going to the survivor joint tenant. And I forgot to change the beneficiary of that asset, so it's not going to my will. It's about making it more manageable for them and understandable that put it in the trust. If everything's in the trust will be the funnel that tells us where it has to go when you die. Where if you die with assets that are probate assets and assets that are joint tenancy assets and assets that have a beneficiary, that's 3 separate train tracks. And those train tracks may never converge. So that's one thing I look at. Where are the assets? Is it better that the client only has one umbrella? Okay. Is there someone who is liable to contest this estate plan? The reason that I would not want to go through probate if a will contest was likely is because a colleague of mine said probate is a lawsuit in which you sue yourself. Okay. I say it's like just giving that person the stage for them to come up and slap the presenter like Will Smith did. Okay. Because we're giving them a case number, we're giving them a court, we're giving them a judge, and we're giving them all the information they need to go, Your Honor, I contest this will. Okay. You can contest a trust, don't get me wrong, but they have to start that lawsuit. Okay. They have to know which court to go to. They have to get all their ducks in a row. And so I don't want to make it easier for someone to contest. Okay. The other reason why a trust can be more helpful in the event of a will contest is in event of a contest to the estate. When you do a will, I have to prove you were competent when you made the will. And that's a very limited period of time. Okay. When you do a trust, I have more data points to use for competence because you created the trust. And then you signed the deed putting the asset in the trust, right? And then you went to the bank and you moved things to the trust. So I could bamboozle you and say, here, this is the dry cleaning bill, sign it. And you sign the will. And it could be argued, that you lack capacity. Certainly in that case you did, because you didn't know what you were signing. Where if I said, well, obviously she knew she had a trust. She went to the DMV and put her car in the trust. She got her deed changed. She told her homeowner's insurance company. She told the bank. This was not a one-off situation. That's all more data points to show that they had knowledge of what they were doing. Okay. The other time that we do a trust, even though otherwise a will might be a fine solution, is when privacy really is important. Like, I'm gonna leave most of my assets to my daughter, and I'm only gonna leave a certain amount to my son. I don't want my son to know who got everything but what he got. He does not have a right to know what I did with the rest of my assets. If I think it would be a problem, then I would have a trust, because he can't go down to the courthouse and see my will and see that my daughter inherited everything he didn't get. In a trust case, he has a right to see only those parts of the trust that apply to him. So I have literally had those situations where the child who thinks they're not getting their fair deal says, well, I want to see the trust. And I go, nope, not happening. Here's Article 2. This is the one that mentions you. Well, what about the rest? Law says I don't have to give that to you. Okay. Could they see it if they started a contest? Maybe. Although I would actually start first by saying, Your Honor, you want to see the trust, let's do it in camera where it's not made, where the other parties can't see it. But again, I want to make it so that they're not going to cause that family disharmony by knowing, oh, well, you got all the assets and mom just gave me a third of it, you know, whatever. So that's why we would do a trust, so that the will isn't something people know about. Okay. I think you now see why I am very much stress the importance of funding your trust. I don't know how to make that go away. Can I do this? I think that's better. The importance of funding your trust, because that is what makes the trust work. Otherwise, we created a beautiful car and we didn't put fuel in it. It's not going anywhere. Okay. So you have to make sure that most of your assets are entitled in the name of the trust. When it comes to retirement plans, we will not put them in the trust, but we want to update your beneficiary designations, and the trust may be the beneficiary. That is a case-by-case basis. Okay. You want to coordinate with your financial accounts, make sure that they name the trust. Now, I've seen some financial advisors and even some lawyers who create a trust, and then they tell the client, you don't need to put your bank account in there, just name the bank account as payable on death to the trust. And I'm like, okay, what happens if the client gets incapacitated? Because the trust doesn't help us. The trust doesn't own it yet. Won't own it till they're dead. Okay. So that is not my preferred approach. It's also psychological. Okay. Once I start to tell people, well, you can keep that out of the trust. You can keep this out of the trust. What they hear is, you don't have to put anything in the trust, right? So I like to be strict and say, everything goes in the trust except retirement plans and the car you own at the time. Okay. When you have a trust as your estate planning vehicle, you have to create it, and then you have to fund it, and then you have to maintain it. Okay. Maintenance means a couple of things. It means making sure that you look at it regularly and that the words in it still fit. That the people you want to inherit, the people you want to do the job, still inherit and do the job the way it says. Or maybe you've changed your mind. Maintaining it also means that as you get new assets, you put them in the trust. And the best way to do that is buy them in the trust. The car, the real estate. Okay. That's why one of the things we do is we have a maintenance plan for our trust-based clients. It's optional. You can pay me to just create the trust. You can pay me to create and help you fund, But most clients, I think that's fair to say, I've never done the numbers, pay me to create and fund and maintain. Okay, because then that's why in 2026, I'm so busy, because all my clients on the maintenance plan who have a trust, we're gonna rewrite your trust. Now, I'm not asking you a lot of questions about what changed in that context. I'm saying, I know the law changed here. I want to change better wording there. I want to refresh it. Okay, make sure it's the best words I can have versus the words I knew to do 10 years ago. I got 10 years of experience. I want to make sure it's in there. Okay. Maintenance is making sure that as the assets you acquire or change banks and all that kind of stuff, that they're still in the trust. Okay. So that's why we still provide that service to clients to say, you know, I don't want you to just stick it in a drawer and think you're done. I've encountered people who say, well, what kind of lawyer are you? Oh, I do estate planning. Oh, I did that. And it just kind of makes me pause for a minute. I'm like, that's like saying I put oil in my car. I'm like, yeah, but you don't do it once, right? It has to be maintained. And so that's part of what estate planning has. So even with a will, I contend it's harder. And that's why it fails more often, because you have to remember to update your beneficiary designations, not just on your retirement plan, okay, but on your life insurance and on your payable and death beneficiaries in your bank account and on anything else that had you name a beneficiary, right? You have to remember that this asset is jointly held in joint tenancy with so-and-so, so the will's not going to matter anyway. Okay. So it's a pretty common scenario when I'm probating a will that not all the assets go according to the will, and they don't even go to the people that are named in the will. That this asset over here is still going to the ex-girlfriend. Okay, I was gonna say ex-wife, but we have laws to deal with what happened in a divorce. Okay, this one over there goes to the child who they haven't talked to for 10 years, and they're dead. So I can never ask them, did you really mean to give that child anything, even though you disinherited them in the will? Right? Even beneficiary deeds, right? I had at least a couple where we're probating. The client literally came to me while they were alive and we did a will, and they didn't tell me they did a beneficiary deed on their house. So when they die, the will's not controlling what happens to the house. I don't know if they forgot. And it's not an easy thing for me to find. They have to know they did a beneficiary deed. So maintenance is important in either case, but I think it's easier when you have a trust. Okay. So that's why we do a lot of work with clients to ask a lot of questions. When they come in and say, do I need a will or a trust? I'm going to go, oh, give me 20 minutes when you're going to answer a lot of questions to me before I can give you an answer. Right? Because I need to know what your goals are and what your assets are. I need to know what the impediments might be. This child who's going to cause a problem, this son-in-law who's going to cause a problem, this child who has a special needs situation, right? This asset that's outside the state of Colorado, this asset that's outside the country is just a whole nother story. Okay. And then we can help you plan it and do it with the right vehicles. If you have any questions about your specific situation, Catherine and I are both offering complimentary 15-minute phone calls. So you can use this QR code, but you're also going to get an email with this. So if you don't know how to use QR codes, don't worry, there'll be a button to press that'll lead you to our appointments that are available for these phone calls. Okay. If you know you need to do planning, you might want to skip the phone call and just schedule an estate planning meeting with us. Catherine and I both offer initial interviews at no charge. That's about 30 minutes of all the questions I just said I was going to ask. So I can get a sense of what your situation is before we make a proposal about what you really need and how much it will cost. Any questions I didn't answer for you?
If you have a will,
Mm-hmm.
and then now all of a sudden you realize I probably need a trust, the transferences.
your will is gonna become useless when it's all said and done. We're gonna do a new vehicle, and the bicycle is even gonna have to be replaced because it's gonna become the pour over will. So if you have a will and you need a trust, you just need to do a trust. And then the will, you tear up the will you had before because you're gonna get the new pour over will. Yeah.
Thank
Okay.
you very much.
You're
I'm gonna
welcome.
run. This is very helpful. I really like your workshops. Thank you.
Thank you.
I know.
They're
Take
fun
advantage
enough.
of that 15-minute call. too.
I like to talk.